Good afternoon and welcome to Going Global's first sponsored presentation on Get the Real Facts on U.S. Work Visas. It is so exciting that we have 500 attendees joining us from almost everywhere in the world except where people are still asleep. So we've got people from the EU, the UK, Canada, the US, Mexico, Argentina, and welcome to the presentation. My name is Marianne Thompson. I am the president and founder of Going Global. And as I said, what an honor it is for you to be joining us and to hear more from our resident specialists, Mark Rhodes and Crystal Malik, on the real facts on U.S. work visas. Let me tell you what the plan is for our conversation this afternoon. I'm going to briefly give you an overview of Going Global, just a 2-sentence explanation, and then turn it over to our friends who will go through their presentation. Please know that we are recording this conversation, even though the presentation will not be available until after we host this again on December 12th. So if you haven't learned enough today, we invite you to join us again on December 12th at the same time. Go through the registration process and learn even more from Crystal and Mark, who hopefully will join us for even more sessions in 2024. Definitely sure that you will have some questions might arise during the presentation. Please feel free to put that in the chat box, and time allowing, Crystal and Mark will take your questions at the end of the presentation. The presentation itself should last between 40 and 45 minutes and give us about 10 minutes to answer whatever questions you might have. You are now looking at just the home page of Going Global, which I hope is not the first time you've seen it. So you've been able to join us for the Going Global presentation because you are one of 3 million individuals via 600 of the leading academic institutions around the world who have access to Going Global. If you haven't explored our resource, please do so and better understand how we provide career and employment resources for more than 120 worldwide locations. That even includes city guides for 40 U.S. major metropolitan locations. So in addition to our career guides, which include hiring trends, work permit regulations, resume and CV guidelines, interview and cultural advice for these major markets around the world, we have 16 million global job and internship postings. A unique feature about the jobs and internships is that you can search them in the local language in addition to English. We have corporate profiles, and we have our own H-1B visa search engine with more than 6 million records and also very detailed OPT guidelines and listings of employers who are known to be OPT friendly. So there's a lot within the Going Global resource that I hope you'll take advantage of. We, Going Global, hosts our own training session several times a month. Just so you know, the next training session will be Tuesday, November 28th. The details about the Going Global training sessions and registration can be found on the Going Global site exactly where you are. So now, with great pleasure, let me tell you a little bit about our 2 presenters this afternoon. Mark Rhodes and Crystal Malik are well-recognized immigration attorneys with the McCandlish Holton Law Firm in Richmond, Virginia. Both Mark and Crystal work with companies and universities throughout the United States successfully processing thousands of work visas and green card applications each year. Both Mark and Crystal frequently collaborate with college career services offices, providing the valuable insights, part of which they'll share with us this afternoon, regarding the ever-changing U.S. immigration procedures. They're both well recognized, as I said, immigration specialists within their fields. Mark has been repeatedly recognized as one of the best lawyers in America for immigration law, and Crystal has been highlighted as one of the best lawyers in America, ones to watch in the same field. It's such an honor to have Mark and Crystal join us this afternoon and share their authoritative vision and insights with you. With that, I'm going to turn the presentation over and welcome to Mark.
Okay, well, thanks very much. Thank you for the introduction. Pop back on to the opening screen for a second. We are immigration attorneys, and as just mentioned, we process hundreds and hundreds and hundreds of H-1B visas and permanent resident green cards. We work with companies all over the United States, and I can tell you I've been practicing immigration law for about 28 years, and I can tell you that in working with companies all over this country, most employers, most companies have no idea how the immigration process works. So what we're going to try to do here in the course of the next 40 minutes is to give you the typical pathway that we see in our law office that international students use to stay in the United States and work after graduation. And I emphasize after graduation. There are different ways that you can work in the United States if you're an international student before you graduate. But after graduation has its own special rules and regulations, and that's what we're going to focus on today. And we're going to be throwing a lot of information at you, probably more than you can absorb in the course of the next 40 minutes. So I think some of the most important information is up here on the screen right now, which is my contact information and Crystal's contact information. And this is useful because if you walk out of this session and you forget everything that you've heard, and you have questions about the immigration process when you're talking to an employer, feel free to give us a call, send us an email. We're happy to answer your questions. If you are in a career services office, we work with university career services offices all over the United States, serving as a resource to help international students understand this process. So if you're in career services and you have a question from an employer or you have a question from an international student about how the immigration process works, feel free to give us a call, send us an email, and we're happy to answer your question. And we provide this free of charge, so it is a very useful resource for you to hang on to. Next slide, please. All right, so here's the path. And as I said, I've been practicing immigration law for about 28 years, and I have helped thousands and thousands of international students stay and work in this country after graduation. And although there are other pathways that international students could follow to stay and work, I can tell you that for 95% or more of every international student that I have ever dealt with follows the path up on the screen right now to stay and work in the United States after graduation. So I'm going to walk you through this path very quickly, and then Crystal is going to take it and go in a little bit more detail with regard to each of these various steps. So step one for staying and working in the United States after graduation, and I'm going to focus this talk on F1 students. There are other categories of international students in the United States, but far and away the most common is F1. So that's what we're going to focus on. So if you are an F1 student in the United States, the first step to staying and working after graduation is what's called optional practical training. Every F1 student, when they graduate, is eligible for up to 12 months of optional practical training. I call it OPT. Optional practical training is the single best way for you to get your foot in the door with an employer. And the reason it's the best way to get your foot in the door is because the employer doesn't have to do anything. The employer doesn't have to file any paperwork with the government. The employer doesn't have to pay any fees. All the employer has to do is decide that they want to hire you, and you can go to work for that employer using optional practical training, as long as you get a little work card. It's called your Employment Authorization Document, your EAD. It's a work card that looks just like a driver's license. And that work card will allow you to stay and work in the United States for up to 12 months. If you are in a STEM degree program, science, technology, engineering, or math, you get an additional 24 months of optional practical training for a total of 36 months of work authorization in the United States after graduation. While you are working for an employer using your optional practical training, you are going to want to talk to that employer about filing an H-1B petition. The H-1B is the most common work visa in the United States, and it is absolutely the work visa that the vast majority of international students will want to get in order to stay and work for a longer period of time in the United States. The H-1B will allow up to 6 years of work authorization. So you start out with your optional practical training. While you're using the OPT, you will then file for an H-1B. That will allow an additional 6 years of work authorization in the United States. And it's typically during that 6 years that you will want to pursue a permanent resident green card if it is your desire to stay longer in the United States. And let me just touch briefly on permanent resident green cards, because we get this question all the time from international students. They say, oh, I don't want to mess around with OPT, or I don't want to mess around with the H-1B and this H-1B quota and the H-1B lottery that Crystal was going to talk about. Why can't I go and get a green card? Well, the answer to that is there are only very few ways to get a green card in the United States. And it can take a very long time. Very quickly, what is a green card? Once you get a permanent resident green card, it means that you can live in the United States for the rest of your life. You can work in the United States without restriction. You can work for any employer. You can work for yourself, or you can be like a US citizen and not work at all, lay around on the beach all day long. So once you get a permanent resident green card, it has great benefits in terms of working or not working. It also allows ease of travel. When you get a green card, you never have to worry about getting a visa ever again. You can travel freely in and out of the US using your passport and the permanent resident green card. So it has great advantages. The problem is that there are only very few ways to get a green card. Primarily, for most international students, there are only 2 ways to get a green card. There may be some others, but primarily the 2 ways to get a green card are either family-based green card applications. If you have a family member in the United States and that family member is either a US citizen or a permanent resident, that family member may be able to sponsor you to get a permanent resident green card. I'm not going to spend time talking about family-based permanent residents. If you have questions about family members who may be able to sponsor you, for example, a US citizen spouse, if you have questions about family-based permanent residents, go ahead and send me an email, give me a call, happy to answer your question. The other way to get a green card is through employment. That is, if you have an employer who is willing to sponsor you for a permanent resident green card. But the issue with getting a permanent resident green card based on employment is primarily you have to have an employer. I've never known an employer who would sponsor someone for a permanent resident green card before that person went to work using one of the temporary visa options like optional practical training or the H-1B, demonstrating to the employer that you're worth the time and the effort and the money of pursuing the permanent resident green card, and then they pursue it in the future. So for purposes of evaluating your options for working in the United States after graduation, my advice is put the green card away, put it off to the side for right now, and focus on the temporary options that are available to allow you to stay and work in the United States. And those are F1 optional practical training, and then the H-1B. Next slide. One more after that. All right, so let's jump right in. So here's step 1. The most common way for individual F1 students to stay and work in the United States is using optional practical training. And I'm going to turn it over to Crystal now, who can give you the ins and outs of OPT.
What you see on your screen, everybody, is your optional practical training rules. These rules do change periodically, but this has been the long-standing way that you have to look at optional practical training. This is the 12 months of work authorization that you have that are no commitment by your employer. They don't have to pay for anything. They don't have to sponsor anything. They don't have to file anything. They just get to hire you like they would any other employee. You're allowed to apply for the job. You'll have your employment authorization document that Mark talked about, and they'll use that to prove that you have authorization to work in the United States, and they won't have to do anything. No commitment from them. It's all about you finding a job in your degree field. These different little intricate rules, each and every single one of these has to be followed when you apply for your optional practical training. If you're at a US university, they're going to be helping you with this. They're going to be making sure you meet all of these requirements. They're going to be making sure that you file everything on time. They're going to be making sure that every little piece of this is filed within these windows. You see that you can apply up to 90 days before you complete your program or up to 60 days after. You have to apply within 30 days of the OPT authorization by your student advisor at your university. And you can make the card effective for up to 60 days post-completion. If you miss any one of these single deadlines, they're going to deny the application. So it's just really super important that you follow each one of the rules. And if you're doing this 4 years from now, make sure you're following the rules that are valid at the time, right? You're going to be working with your foreign student advisor to make sure that you meet these requirements. All of these applications are filed online now. You have to make sure that you have permission from your designated school official, your international student advisor, before you submit the application. One of the big mistakes we're seeing right now are people who don't get their student advisor's permission first. They don't get the one document that they need from their student advisor, and they try to submit their application without help. Super important that you make sure that you've talked to your student advisor first, you've gotten what's called your I-20 form, and you submit your application correctly in the right time period with all of the documentation, including that I-20 from your foreign student advisor. Again, every person who graduates at a certain degree level in the United States is eligible for this 12 months of optional practical training.
Crystal, let me jump in real quickly just to make a couple of observations. First, to apply for OPT, you don't need a job offer. You don't even have to have started looking for a job yet. You are automatically eligible to apply for this OPT work card once you are within 90 days of graduation. So that's a very important point. The second point, and this is one thing that Crystal just emphasized, and that is most schools in the United States will provide information and seminars and informational sessions on applying for OPT. You should attend as many of those as you can. The rules are a little complicated, and it's very important for you to make sure that you follow each of these rules so that you apply for that card, you get that card in your hand, and you are ready to go to work after graduation. Back to you, Crystal.
And your international student advisor wants you to succeed on this. This is very important to them. They're going to provide checklists. They're going to review your application with you. They're going to do everything that they can to make sure you're successful in this. So it's really important to use them as a resource. Note the very last bullet point that you can't have more than 90 days of unemployment after you've gotten that card in your hand. So just make sure that you're paying attention to every single one of the little rules that apply. All right, if you're in a STEM field, science, technology, engineering, and math, there are 24 extra months of employment authorization that you can have. This is where the employer has just a teeny tiny little bit of responsibility, right? You have to be in a STEM field. That's you. Your degree has to be in a STEM field. The employer doesn't have to sponsor anything. They don't have to pay for anything. All that they have to do is be an E-Verified employer, which is a government plan that verifies employment authorization. Lots and lots and lots of companies are E-Verified, and some smaller companies, when they find an employee like you guys that they want to be able to keep past their optional practical training, are willing to sign up for that program just to be able to be in this STEM OPT extension, be your employer during that time. The one thing that they have to do is they have to be willing to be e-verified and sign a training plan. So what the training plan is this little application that you fill out most of, and then your employer has to verify that they're going to offer you a job in your degree field that will provide training and oversight to you that will help you to gain more understanding of the degree that you have just completed, the skills, the coursework, the training that you've already had in your degree program. They're going to help you further that in the real world. And that's what the training plan says. When you apply for this, it again has really strict rules for when it has to be submitted. So you have to submit your STEM OPT application to U.S. Citizenship and Immigration Services before your current optional practical training expires and within 60 days of the student advisor's authorization. Again, students have this I-20 form. The DSO, International Student Officer, Designated School Official, is going to give you a new I-20 that authorizes you to apply for a STEM extension, but they're not going to do that before you submit your training plan signed by your employer so that they can verify that your job is in your degree field, that your employer has committed to providing this training, and that it's all interrelated, right? So the International Student Officer is going to give you your I-20. You're going to use that to apply for your STEM extension, which will get you 2 extra years of work authorization. Very little input has to be made by your employer, but this is where they start getting a hand in making sure that you're successful in getting your employment authorization. There are reporting obligations for this. So if you're in your optional practical training or your STEM optional practical training, you do have to continue to have a relationship with your school in the International Student Office because your employment has to be put into your student record. So the entire time, that entire 3 years that you have work authorization through your school, you're going to be reporting your employment to your designated school official. If you change employers, you're going to have to get a new training plan. That new employer is still going to have to be e-verified. But you're going to keep that relationship and keep your record, your immigration record, up to date with your international school office, international student office.
Now here's the key with OPT. Once you go to work using your OPT, you're going to know that there's a clock ticking. It's either going to be a 12-month clock for regular OPT or the 36-month clock for those of you in STEM programs. At the end of those time frames, you're going to want to be thinking about a longer-term work visa to stay in the United States, and the most common longer-term work visa is the H-1B. So let's jump to that.
Awesome. And keeping in mind that you don't have to wait until the end of your optional practical training, your employers can be trying to get this H-1B visa for you the entire time you're in optional practical training. So what we have here is the H-1B, the most common work visa for college graduates. Why? Because that is exactly who it was designated for. The H-1B is for specialty occupation workers. That's college graduates. It's designed for any national, a person from any country can have this particular visa as long as they have a college degree, a bachelor's degree or higher. They have a job offer where the degree is related to the job, and they have an employer who wants to sponsor that. This is where the employer really starts having to take full responsibility for your sponsorship. They have to actually file documents with U.S. Citizenship and Immigration Services. They have to take charge. One thing that people get worried about is this prevailing wage requirement you see at the bottom. But in our experience, this is not typically an issue. Typically, when you have an employer who wants to hire an international student, wants to hire somebody out of their optional practical training, they're going to be paying this wage. They're going to be paying higher than this wage. There are some employers where it's a sticking point, but it's not something that you're going to have to worry too much about. At this stage, employers don't have to prove that they can't find a qualified U.S. worker. They don't have to advertise the job, but they're able to just go ahead and sponsor the best employee that they would like to hire.
All right, let me jump in real quickly on one of those issues, which is the degree requirement. So the key to H-1B is you have to show that the job that you are going to do requires a specialized type of degree to do the job. For example, an accountant has to have an accounting degree, or a civil engineer has to have a civil engineering degree. There needs to be a close correlation between the duties that you're going to perform and the degree that you hold. And this requirement is the single biggest reason that the Immigration Service denies H-1Bs. They get an H-1B application and they say, I'm looking at the job duties and I don't think that these job duties really relate to this person's degree. So an exercise that we typically require employers to go through when we are doing H-1Bs is to take a bullet point listing of the job duties, list them down the page, and then I want the student to go through and tell me the coursework that the student took in their degree program that relates to each of those duties. And if you can make a close correlation between the job duties that you're going to perform and the degree coursework that you took, you'll have a strong H-1B. If you cannot make a strong correlation, then you might want to start looking for a different job because you're going to have difficulty getting the H-1B. Back to you, Crystal.
And a lot of people do consider this before they start studying in the US. They start looking at what kinds of jobs are hiring in the US and then plan what type of degree they might want to have for that particular job. So thinking about it on the front end is also quite important because this is going to be a deal breaker, making sure that your degree is directly related to the job. So with the H-1B is valid for, as we said before, a 6-year maximum. They're typically given in 3-year increments. So your employer would apply for 3 years the first time that they apply, and then they'll apply for a second 3-year extension afterwards. It's during this time, right? It's during this time, during this 6-year authorization, that you'll start kind of thinking about the green card process. It's once you're in this, about halfway through, your employer is going to really want to be thinking about how they can keep you permanently. So with H-1B, you can only work for the employer, the exact employer who sponsors your H-1B, doing exactly the job that they sponsored you for in the exact location that they described in the petition. It's going to be super, super important that when you're in your H-1B, if something changes about the job, you need to make sure that whoever is handling your H-1B at the company knows about that change. If you've moved from California to Tennessee, or if you've been promoted from line tech worker computer systems analyst to manager computer systems analyst, you're going to need to make sure that somebody at your job knows that so that your H-1B can be updated. If you want to change employers after you have H-1B, you're allowed to do that, but you have to find another employer who's willing to sponsor your H-1B. They have to file a new petition. You can start working as soon as that new petition is filed. It's called portability in immigration law. It's going to allow you to switch employers at your leisure, at your choice, but it is going to require that new employer to also sponsor you. And you will need the receipt notice to be able to document that you have already applied for this change of employer with your H-1B. So here's the main issue with H-1B. The H-1B has to be paid for and sponsored by your employer. You cannot pay the attorney fees or the filing fees for the H-1B. Some employers, some smaller employers maybe, may not know this yet, and it may be something that you have to kind of negotiate with them. They have to understand it before they start the process. But it is super important that you keep an eye out. Some people find predatory employment offers. They find an advertisement in a newspaper that says that you would have to pay for someone to sponsor you. Those are the kind of things you want to avoid, you want to run away from, because this is a particular visa type where the employer is responsible for all of those fees. What you see on your screen are some of the typical fees that would be assessed for these types of petitions. The one fee that a student could possibly pay is this premium processing fee at the bottom. If you're talking about the premium processing is where the US Immigration Service would process your application in 15 days. If you're doing that for a convenience for you, like you just want to take a vacation or you want to travel or you need it for a driver's license application, that's something that you could cover. That's the only fee that you're allowed to cover, and that's the only circumstance where you would be expected to cover that. So understanding that if you're being sponsored by an employer, they have to do the sponsorship, they have to pay for the sponsorship.
Let me jump in real quickly about the fees. I can tell you that in our office, in the years that I've been practicing immigration, we've probably processed, I don't know, 35,000, 40,000 H-1Bs, a lot. I can count on one hand the number of employers who elected not to go forward with an H-1B because of the cost. The costs are not that significant for employers. and they treat them just like they would treat any other recruiting expense. If they find a talented international student, they are more than willing to go forward with the H-1B fees and the costs. And as Crystal mentioned, there are basically two categories of fees. One is the attorney fee, which is our fee. Different attorneys charge different amounts. In our office, we charge $2,600 for an H-1B filing. The government filing fees, we listed them up here on the board. The shortcut answer is the filing fees. If you're working for a company that has 25 or fewer employees, the government filing fee is $1,710. If you're working for an employer that has more than 25 employees, the government filing fee is $2,460. So if you take my fee, $2,600, the government filing fee, $2,460, you're looking at around $5,000 for an H-1B. I can promise you, employers are not intimidated by that, but it's important for you to know the basic cost parameters so that you can explain this to an employer if they have questions. All right, so let's jump to the lottery, which is the big issue.
Yeah, this is the main barrier, right? Every fiscal year, the government releases 85,000 H-1Bs. The government's fiscal year runs from October 1 to September 30th. They reserve 20,000 of the H-1Bs that are available for U.S. degree applicants, advanced degree applicants. So people who have a master's degree or higher from a U.S. university. Those people are reserved for 20,000 of the visas, and 65,000 can be any degree type, which could include people who have that U.S. master's degree, or people who have a bachelor's degree, or people who have a foreign degree. It doesn't matter. That's your 65,000. We're sitting here right here in the middle of November. There are none of these numbers are left. They are all gone. The way that the U.S. government handles this is that even though they open up this quota on October 1st, they actually have employers pre-register back in March. The statute, the U.S. law allows these immigration petitions to be filed 6 months ahead of time. So 7 months ahead of time, they start the registration. So what employers do is they have to create an account on the USCIS website. We do recommend that if your employer is going to be using an attorney, that they use an attorney for this step, because this is a very, very, very important application. This is what allows you to have your entry, and if it's not done correctly, you will not even be entered in the lottery. It's a very first step. So they pre-register typically in that first 2.5 weeks of March. It's a very low barrier to entry. Right now, they're charging a $10 registration fee for employees. They can enter as many employees as they want, but they can only enter each employee once. So they cannot submit multiple entries on your behalf. It has to be one entry from that employer for you, and it does identify each employee by name. They're planning on starting a system where you're really tracked by your passport number. So the employer has to put in base information about you. They enter you into the lottery. They get a confirmation screen that lets them know that their lottery entry has been accepted. And then that very first day of April, they have a target where they have their actual lottery draw. They always say that they're going to draw by April 1. They typically start about 3 days ahead of time, and they release their selections by email and in the online account over the course of about 3 to 4 or 5 days. And they do start that early so that they can get those out. It's just a lot of applicants and a lot of people to notify.
So let me jump in real quickly. So as Crystal mentioned, for the quota is released on October 1 at the beginning of the shaded area on the screen. Employers can pre-register during this pre-registration period. It's always 2 weeks or so. It's always in March. They change the dates every year, but they'll let us know in February when the registration period takes place. So this past year, during the registration period for the quota released on October 1 of 2023, the 85,000 quota, the government received over 760,000 registrations. That's why they have to do a lottery. They get 760,000 registrations for 85,000 slots. So all they do is they do a random lottery. They first pull out 20,000 advanced degree cases. You'll check a box to say whether you're in the advanced degree lottery. And then they pull out 65,000, which is the regular quota. Once they've pulled out 85,000, They stop. And they notify those people by April 1 who've been selected. Others are just rejected. So the odds are not great, but it's very important for you to understand this lottery process to make sure that you pay attention to the registration date in March, and you talk to the employer to make sure that you get a registration filed during the proper registration period.
And that they do it from an email address that they're going to be able to track, and that they don't lose their login for that website. Because if they can't log back in, or if they don't have an attorney who can log back in on their behalf, they can't access the registration, and there is a document within their account that they have to use. They do throw out quite a bit of lottery entries, so it is really important that you have these properly submitted. If the employer accidentally submits twice, they will just disqualify all of the entries. They won't just pare it back down to one, they will disqualify all of the entries. If they have fraud indicators on the application, they also toss those out. So it's just very important. They are being very careful because they have had what they suspect to be a high level of fraud on these. Very important to fill these out correct.
So let's look quickly at just a basic example of how the lottery is going to work. So many of you are going to graduate in the spring. So let's say you're graduating in May, and you can see May there on the left side of your screen. So if you're going to graduate in May, you look back at the registration period back in March. Well, guess what? You're graduating in May. The registration period is in March before you even graduate. Can you file a registration before you graduate with your degree, before you get the degree that you're going to rely on for the H-1B, whether it's a bachelor's degree or whether it's the advanced degree? And the answer is yes, you can definitely apply in advance before you can file the pre-registration before you have the degree that you intend to rely on. So let's say you're in an advanced degree program, you're graduating in May. You want to file an advanced degree registration. You are permitted to do that. File the registration in the advanced degree lottery as long as you will have the degree that you're going to use for the H-1B by the time you graduate. Similarly, if you're getting an undergraduate degree, you don't have it yet during the registration period, you can still file that registration as long as you will have your undergraduate degree by the time the H-1B petition is filed. So click back to that, to the timeline. So your graduation is in May. The registration is in March. The government will notify lucky winners by April 1. You won't be able to file your H-1B petition on April 1 because you don't have your degree yet. You can file the petition anytime within 90 days of the notification that you've been selected. So you get to your May graduation, that's within the 90 days. You file your H-1B petition. Let's say it gets approved. Do you automatically change to H-1B? No, you don't change to H-1B until October 1. That's when the quota is released. So how do you work between May when you graduate and October 1 when the H-1B is approved? OPT. You've got to get OPT. That is what's going to bridge you to the work authorization using H-1B. Back to you, Crystal.
All right. So thinking of all the different scenarios that could happen, it's completely permissible for your employer to file that first year before you even started working on OPT. It's also permissible for them to continue filing for you each year thereafter until you are selected. If you're graduating in May, you're thinking about that October 1 start date. If you're graduating in January, you're still thinking about that October 1 start date. Your DSO can help you figure out a strategic way to file your optional practical training, trying to make sure that you get the most bang for your buck on your optional practical training time and create that overlap for your H-1B. All right. So we've talked about this cap gap relief. That applies to you if you are selected in the lottery and your employer files a petition on your behalf while your OPT is still valid. Your OPT gets extended all the way to September the 30th. Noting that, I've lost my train. Okay. Noting that you will have this cap gap so that you can continue working. All right. So we've talked about the H-1B lottery. We've talked about how it's very difficult sometimes to get a petition selected in this because of the sheer volume, the number of people who apply every year. There's a group of organizations that are exempt from the H-1B cap, from the H-1B lottery. These organizations can apply for as many H-1B employees as they need. They can apply any time of the year. They are not limited to that entry in March. They're not limited to waiting for the lottery, none of it. These organizations are designated by statute, and you have to make sure that the employer fits into one of these categories. We have universities, we have nonprofit organizations that are affiliated with universities. This could be any number of organizations that have affiliation agreements or cooperative agreements with universities. Think research facilities, think hospitals, think sometimes schools, public schools who have student teaching programs. It can be a nonprofit research organization, or it can be a governmental research organization. And you would be surprised how many organizations fit into these requirements very comfortably and are allowed to apply for H-1Bs for their employees all year round. We're not just talking about, if you're talking about universities, we're not just talking about university professors. We're talking about every type of employee that a university or a nonprofit research organization has to hire. So IT people, admissions officials, counselors, all of the different broad spectrum, physicians, all of these people can fit into these cap exemptions. They can still hire these employees using their H-1B cap exemption. They do have to be federally designated by the IRS as a 501c3. Each one of these employers is going to be able to show that and document that. It is important. A lot of the universities, I mean, all universities already know this. They use this very, 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 very well. So if you're hired by a university, they're going to have a complete department that is going to help you with this. What you may find is that some of these other organizations aren't aware that they are cap exempt, and they might actually need you to push them in that direction to kind of to let them know, to educate them as to their ability to use this as a resource for their own recruiting. Every year, we get lots and lots of employers who discover that they are exempt from the H-1B cap because they contact us to try to file a cap petition, and we're able to determine that they actually are exempt, and we can file it through a completely different system and not have to have them subject to this cap. So outside of the H-1B, there are some other limited types of visas. Each one of these bullet points is a different visa type that you could possibly be eligible for. It's important to note that we talk about the H-1B the most, right? Because nationals of every single country on the planet can apply for an H-1B. A lot of the other visa types that we're talking about here are limited. So if you're from Canada or Mexico, there's a visa type called the TN, and the TN is very, very similar to the H-1B in that it's for professionals, right? What happens with the TN is that they actually have a list of the profession types that can qualify for that visa, and if you fit into that and you're a citizen of Canada or Mexico, we can get you a TN. There's no lottery, there's no cap for those. As many applicants as are qualified can apply for them. Chile, Singapore, and Australia have a small carve out of their own treaty-based H-1B type visa, so H-1B1 or E3. So if you are from one of those countries and you think that you would normally qualify for an H-1B, that same specialty occupation criteria where you have a bachelor's degree or higher in a specific specialty and a job that is directly related to that, that requires that degree, you could qualify for these H-1B alternative visas. So
let me jump in real quickly and buzz through the L and the E so we can open it up to questions. So as Crystal said, in terms of alternatives to the H-1B, they are extremely limited. You have the 5 countries across the top of the screen. There is an option for individuals working for multinational companies that have operations outside the U.S. and operations inside the U.S. You first have to transfer outside the U.S. for at least a year. If you do, you may be able to qualify for an L to transfer back into the United States, obviously a limited option. There is an option called an E visa only for citizens of countries that have treaties of trade and commerce with the United States. China does not have one, India does not have one. But you can Google E visa treaty countries to see if your country has a treaty of trade that may qualify you for an e-visa. And if you have e-visa questions, you can send me an email, give me a call. I'm happy to answer your questions. But with the exception of the H-1B and these very limited alternatives listed on the screen, most students who don't get selected in the lottery either go back to their home country or they re-enroll in full-time study. Those are essentially the options that are available. And this is the part of the program that is always sort of disheartening for me, because the H-1B is so important and there is such a limited number. But in the end, as an international student, it is always important for you to plan ahead. You've got to plan ahead during your last semester of your degree program to get your OPT. While you're working using your OPT, you need to plan ahead to do that registration for your H-1B. If you get the H-1B, then you can start planning ahead to look towards a permanent resident green card. And with that, we'll turn it over to some questions.
Mark, this is Marianne. I'm going to step in with a few questions that I have on my end from you all. Number one, as a lawyer myself with no training in this, I am flabbergasted at everything you shared today, and I think we're going to have you and Crystal back. I would prefer once a week. That's not going to happen. For it to sink in with me, there's a lot to really get and understand here.
Yes.
Before we get to the questions, I just want to highlight again, based on the information that you and Crystal provided today, a couple of things. Within the GoinGlobal resource, everyone on this call has that. We have a historical database of 6 million H-1B visa application records, so that you can have a sneak peek at organizations who have year after year after year submitted their interest in hiring international talent. That doesn't mean they received an H-1B for that person or that position, but if you wanted a short list of who is going to be open after that OPT experience to hiring you, there's your list. Now I understand, Mark and Crystal, why there's so many universities in that list. It's because they're in one of these special alternative categories. So, and I really appreciate, Mark and Crystal, your comments about doing all your homework. And as a professional in the global career and employment field, I think it is important to you cannot count on getting an H-1B. You must pursue simultaneously multiple options, with certainly the great hope of getting the H-1B at the top of your list. But you cannot start to explore other options at the 9th hour when that H-1B may not come through. So exploring multiple options, I think, is very important. I do want to talk 1 second, and I know this isn't a question, but I'd like to share this information about the L visa Mark was talking about. GoinGlobal as an employer directory, 450,000 profiles of multinational companies. So say that your option had to be you returning to your home country, then laterally back after 1 year to the U.S. Say you're from Mumbai, India. Go and see what American-based companies have a location in Mumbai that have positions open in your degree field, with the thought process that you would lateral back. I also want to remind you, what did you take away from this presentation? My number one takeaway: OPT, OPT, OPT. If you want to successfully pave your path to H-1B employment, pursue the OPT. And that is in your basket of opportunities. You direct and drive that car. So Going Global has pages worth of guidelines on OPT, including links to 500 employer job boards of employers we know to be OPT friendly. These are listings of employers who have hired OPTs. So, complementary to Mark and Crystal's comments, I just want to remind you how much is in Going Global that's accessible to you to jump into this process. So without taking up more of the time that was not even allotted to me, I want to just ask Crystal and Mark one question, and you talked about it, but I'm going to ask it again. Should an international student studying here in the United States try to go jump the gate and go directly to a green card instead of going from OPT to H-1B? Do you go from OPT and then say, forget an H-1B, I'm going for a green card? Or should you try to go OPT, H-1B, and then a green card? What's the best route?
Go ahead, Crystal.
Well, it's really super important that you understand that you need this non-immigrant status in order to continue staying and living and working in the United States. So it's really important not to skip any steps. It's really important to follow the OPT, follow the STEM OPT, follow the H-1B, or any other non-immigrant option that might apply to you, so that you'll be able to stay here, live, and work while you try to think about and pursue green card options later. If you don't have permission to be in the United States and you stay, you could make yourself ineligible for that green card option. So it's really important to know that you just can't skip steps. You have to take each step in turn.
And that's important, because applying for a green card, even submitting the applications, does not give you a basis to remain in the United States. You have to maintain your underlying immigration status, whether it's F1 or whether it's H-1B. And in terms of applying for a green card while you are F1, as I said, the most common way to get a green card is through employment. So you have to have an employer who will sponsor you for the green card. The employment-based mechanism to get a green card is going to take a minimum of 2 years. And if you're from China or India, it could be many, many years beyond that. So the number of years that it will take to get a green card, it will be much longer than your F1 OPT will allow, requiring you to get an H-1B in order to maintain an ability to stay in the United States while you pursue the green card. There are some options that would allow you to pursue a green card on your own, based on your own particular outstanding skills or abilities that are in the national interest of the United States. Those are extremely difficult cases. I process many national interest waiver cases. It is not enough that you are working in a field that has importance to the United States. There are many fields of professional fields that have importance to the United States, like nursing, for example. Not every nurse is going to get a national interest waiver just because nursing is important. To qualify for a national interest waiver, you have to show that you personally are doing work that has national significance beyond just your employer or the clients that you work with. You have to show that your work has national importance. If you believe that you have a CV that may qualify for a national interest waiver, send it to me. I'm happy to review it. I review many, many CVs for national interest waiver. I can tell usually in about 5 minutes if I think you're going to qualify. Next question.
Crystal, I've got a lot more, but I'm going to turn it over to you. Any questions that have come into you that you'd like to answer?
I've been answering them one by one on the chat. There are several questions that I really, really like here. If you've asked a question that's really highly personal, that's something that's specific to only you, what I would recommend is giving us an email after the presentation. And you can do that anytime, today, tomorrow, whenever you're ready. And you can send us these specific questions that are case specific. But what I'm going to try to do is have us address some questions that are that are general to everyone. So the question that we always get is, how am I going to answer the question about whether or not I need future sponsorship for an H-1B? Am I going to have to mark that yes or no? Do you want me to address it, Mark, or do you want to address it?
Go ahead.
Yeah, so and I did address this one on the chat. When you are an OPT student and you're filling out an application that asks if you're going to need future sponsorship, that question does two things, and one of them is for the employer and one of them is for you. You have to mark yes to that question if you don't already have a green card, because otherwise, after your optional practical training, you're not going to be able to work. You're going to have sponsorship in order to continue working. So marking that question yes identifies that for the employer. It lets them know what they're signing on for, if they're going to need to do this sponsorship process. And it also lets you know if they don't take you further, it cuts out a period of time where you would be working for an employer who's not willing to sponsor. It gives you a heads up, just like it gives them a heads up. So here's another question. Do I need an H-1B even if a company wants to hire me with a freelance contract for a remote working position?
The answer to that is you can only work in the United States, even as a freelancer, if you have a proper work visa. You can only get an H-1B if you are an employee. You cannot work as an independent contractor using the H-1B. You have to be an employee. And if you are working as an independent contractor, freelancer, you can only do it using a valid visa. So if you don't have one of those visas on the alternative screen that you can qualify for, you're not going to be able to work as a freelancer at all.
And if your job is remote outside the US, that's going to be completely different, right? If you're not working inside the US, none of this applies to you that we've been talking about today. If you're a remote outside the country, then you're going to have to worry about the rules and regulations for working where you're working.
That's correct. U.S. immigration rules only apply if you are here physically present in the United States. If you leave the United States, even if you're working for a U.S.-based company, you don't have to worry about any of these rules.
So I have a question, because I get posed that question with Going Global. So what you're saying is a visa is determined by your physical location and your physical place of work. So if you have returned to my favorite country, I like to use as an example, if you are based in Mumbai, India, and you accept a remote job with Google headquarters in California, a visa is a non-issue because you're based in Mumbai, you're working out of Mumbai, though you're working for a US-based company, because you're not physically based here, then a visa is a non-issue. Is that what I understand you to say?
That is correct.
Wow. Well, I've got to throw into the conversation, every day we see hundreds more remote, freelance, stay-at-home, virtual, telecommute jobs pop into the Going Global system. So they're growing by the hundreds daily. You thought it was a COVID phenomena? It's not. It is a permanent employment status. So, wow, interesting. Again, it's another one of those things you should be thinking about and exploring, another egg in your basket in case the H-1B doesn't come through. There is no harm in any aspect of your life of creating multiple options. So with this, I'm going to end the presentation with Crystal and Mark. Extraordinary, exemplary information. We see why you all keep getting awards every year for your knowledge and expertise by the American Immigration group here within the United States. So kudos to you all. I learned a lot today, and I'm hoping to keep my job right here in the United States. So if you'd like to learn more, if you'd like to hear more from Crystal and Mark, please remember that we, again, will have the benefit of their expertise In December, you'll have to register again. And secondly, I can't encourage you enough to complement what you've learned today by utilizing the Going Global resources and by joining us for an upcoming training session, next one scheduled for November 28th. Mark and Crystal, if we had the mechanism to show you these 500 people on a screen all doing clapping, that's what's going on. So thanks to you both, greatly appreciated. Early happy Thanksgiving to all. What a gift to have you join us today. On behalf of Going Global, Mark and Crystal, thanks for joining us and hope to have you join us again in the future. Goodbye.
Thank you.